Over the past 2 decades, we've seen vaccine mandates by states. During the 19th century, states have mandated some smallpox vaccine. We've seen school mandates across all US states, and we've seen some employer mandates. For example, in the past 2 decades, many hospitals have mandated influenza vaccine, MMR, hepatitis B, and other vaccines. So vaccine mandates are not new. Let me start with the federal government. The federal government is a government of limited power. That means that it only has a certain sphere in which it can operate. It probably can't mandate vaccines for all the adults or all the children in the United States. On the other hand, the federal government does have the power to mandate vaccine for federal employees. It does have the power to require vaccine, for example, for interstate or international travel, and it has the power to require it for other public transportation that crosses state line. So the federal government has those powers, and we've seen the federal government use its power, for example, by requiring federal employees to vaccinate or test, something I'd refer to as a soft mandate. It's not vaccinate or you're fired, it's vaccinate or test. States are the next level, and states have the broadest public health power in the United States. They have what we call the plenary power, the power to regulate public health generally. And in fact, it's their job. They're supposed to regulate in the public health. The question is, how far can they go? We've seen several states put in place mandates in different flavors. California, for example, mandated that healthcare workers be vaccinated, implying that if they don't, they're going to be fired. Mandated that employees be vaccinated or tested. And New York is talking about vaccine mandates and entry to restaurants. Then we're seeing private actors' mandates. We're seeing employers tell their employees you need to vaccinate or there'll be consequences. Some are saying vaccinate or you're fired. Some are saying vaccinate or test and mask. Those two are legal. Generally speaking, employers have the authority to set workplace conditions and the duty to keep the workplace safe. Finally, we see private business. Some of them require customers to show proof of vaccine. And again, private business have the right to set the terms. Just as a private business can say no shirt, no shoes, no service, they can say no vaccine or service. There are caveats to all of those. So the big caveat that covers all of these is, can you mandate a vaccine under an emergency use authorization? These vaccines are not yet licensed. They're under an EUA, emergency use authorization. And it's an unanswered legal question yet. It's unanswered because this is the first time we have a vaccine under an EUA for the entire population. But we have growing indications that yes, you can mandate a vaccine under an EUA. The one court that has ruled on it, a federal district court in Texas, upheld an employer mandate for this EUA vaccine. That's Regis versus Houston Methodist Hospital that allowed the mandate to stand. The Office of Legal Counsel, the president's advisor, has come out with a reasoned, detailed opinion that says, yes, you can mandate this EUA vaccine. Both the federal government can and private actors can. So we have several indications. Neither of these are going to be binding on any other court, but both are persuasive and courts can look at them to support keeping the mandate. So it's still unsettled, but there are more indications that we can mandate. There's a number of other caveats you need to keep in mind. All employers need to consider federal anti-discrimination law. The American with Disabilities Act requires employers and many private businesses to accommodate people with disabilities, which includes people with real medical reasons not to vaccinate. That means that if you have someone who medically can't be vaccinated, you have to accommodate them. What does accommodate mean? It might mean allow them access, allow them to stay employed or allow them access to the business, but with conditions like testing or mask. Another caveat is that under the Civil Rights Act of 1964, if employers and only employers have to accommodate employees with sincere religious objections, and again, accommodation may mean test and mask instead of vaccinate. And the current Supreme Court have already signaled that for freedom of religion, it's going to apply a pretty strict standard. It's not clear whether the court will demand a religious exemption from a vaccine mandate. We just don't know. It's really hard to police whether the person really has religious objection or not. But we will have to see what the courts do with that. And finally, if the workforce is unionized, the collective bargaining agreement may require negotiating with the union before you can mandate. That's going to depend on the specific collective bargaining agreement, and it's going to be a case-by-case question. Several states have passed law limiting the ability to mandate vaccine or require documentation, and that those laws, unless they're challenged and validated by a court, are going to limit that ability too. People who are still hesitant about the vaccines are probably not going to be swayed by FDA approval. It will make a larger difference to the legal situation. First of all, it will remove the argument that you can't mandate these vaccines because they're under emergency use authorization. So that will be a big difference and will probably give a lot more employers or universities confidence to mandate. It will also have a direct legal impact on some specific places. And several states that passed bill prohibiting mandates conditioned it on FDA approval, said that the mandate will become operational when you have FDA approval.